Hello, I'm Jacqueline Almond, a solicitor and partner at IBB Law. This is a summary of a presentation about powers of attorney, which I have been making for several years to carers and those supporting a family member or friend who may lack capacity to make decisions. All adults are assumed to have capacity to make decisions unless it is proven otherwise. Capacity is a legal test and is both time and decision specific. This means that someone may have capacity to make some decisions but not others, or may perform better at different times of the day. Incapacity can arise for many reasons, including dementia, mental illness, head injury, drug or alcohol abuse, a learning disability or illness. In assessing capacity, an individual must be given support, such as appropriate choice of language, use of pictures or otherwise. Evidence of incapacity can arise if an individual cannot understand information after it has been explained to them in an appropriate manner, retain that information long enough in order to make a decision, weigh up the information to reach a decision, and communicate a decision even after appropriate decision and assistance is provided. If someone lacks capacity, there is no automatic right for anyone else to make decisions for them. That includes spouses. It also includes next of kin, which has no legal status, even though I do still see it being used from time to time. If you hold a joint bank account and the bank is aware that one of the joint holders is incapable, they will usually freeze that account. That is in accordance with advice from the British Bankers Association. The reasoning behind this is that the joint account can only operate if there is continuing agreement of both parties that both can withdraw up to the amount allowed on that account. If one party loses mental capacity, then they are unable to agree those terms. The same applies to third-party signatories on a bank account. If you lose capacity, then you can no longer agree to the terms of that third-party mandate. I have come across banks suggesting that a parent puts an account into joint names so that a child can continue to use that account for the parent. Great care needs to be given to this. The account could be frozen, as I have explained. The child could withdraw all of the money. But the main problems come about after the parent has died. The bank will treat this as a joint account and will pass the account into the name of the child. However, that may not be what the child and the parent intended. The parent in particular probably wanted the account to be added to the rest of the estate and split between all of their children. If the child who held the account won't agree to that, then problems can arise. If the individual's assets are modest and made up of state benefits and one account, then becoming an appointee is an option. You would need to contact the Department for Work and Pensions for this. They will visit the individual to assess if an appointee is needed, and they will interview you to ensure that you are suitable. This, however, is not a suitable option if you have several bank accounts and other types of assets. Enduring powers of attorney were introduced in 1986. Anyone who has an existing enduring power of attorney must know that this remains valid even if it has not yet been registered. However, enduring powers of attorney only apply to financial decisions. In 2007, as a result of concerns about the abuse of enduring powers of attorney, lasting powers of attorney were introduced. There are two types: property and financial affairs and health and welfare. All powers of attorney allow you to choose in advance who you want to be able to act on your behalf if you are unable to make decisions at some stage in the future. In addition, if you wish, financial lasting powers of attorney and enduring powers can be used even if you retain mental capacity, but perhaps there is a physical reason why you cannot act, or perhaps you would prefer to have someone to help you. It is important that you put a lasting power of attorney in place at a time when you fully understand what you are doing. You need to be able to understand what the document is. You need to understand who you are appointing and who perhaps you are leaving out. What decisions can these people make for you? Do you want to be able to restrict what they do? You need to understand that if it's a health and welfare lasting power of attorney, those attorneys can only make decisions that you are unable to. You need to understand that a lasting power of attorney cannot be used until it has been registered by the public guardian. More on this later. You can revoke a lasting power of attorney at any time, provided that you have the capacity to do so, and even after it has been registered. You also need to be able to understand the consequences of not entering into a lasting power of attorney, and more on that later as well. You can appoint as many attorneys as you want. Usually it is not a good idea to only appoint one, because what happens if he or she is unable to act? You might say that you would then enter into a new lasting power of attorney, but you may not have capacity at that time. You do, however, have a choice about how you appoint your attorneys. You can appoint them jointly. Most people don't choose this option because it means that all of your attorneys have to act together all of the time. If one of them is unable to act, for example, if they are on holiday, then the others are unable to act at that time. If one of them becomes permanently unable to act, then the appointment of all of them comes to an end. Most people choose to appoint their attorneys jointly and severally. This means that any one of the attorneys that you appoint can act. However, you need to be aware that it could mean that they go and act in different directions, and therefore, as I mentioned before, it is important to choose people who get on and will act together in your best interests. If you want, you can have a combination of these options and have some decisions that are made jointly and some which are made jointly and severally. Great care is needed if you choose this option because you need to set it out very clearly in the lasting power of attorney. You will also need a certificate provider. This is an independent person who is certifying that you are entering into the lasting power of attorney of your own free will and that you understand what you are doing. The certificate provider doesn't need to be a professional, so a neighbour or work colleague that you have known for at least 2 years can do this. However, if there are doubts about capacity, it is a good idea for the certificate provider to have professional experience in this area. So your GP, solicitor or a social worker, for example, can then assess that you are able to understand what you're doing and that you are not being unduly pressurised. They can also record this so that if a question is asked later, they can produce the record of their assessment. The process for completing the lasting power of attorney has to be followed precisely. Everyone has to sign in the right order. The donor signs first. That's you, the person putting the lasting power of attorney in place. Then the certificate provider, and then the attorneys. The attorneys can sign in any order and they don't need to sign at the same time or even within a few days of one another. However, if this is not followed, the Office of the Public Guardian will not be able to register the lasting power of attorney, and you will either need to take remedial action or start all over again. Registration of your lasting power of attorney can take place at any time, but most people do it as soon as the lasting power of attorney has been completed. In that way, if it is needed, it is ready to use. Registration should take around 12 weeks, but during the COVID-19 pandemic, it is taking longer. It costs £82 to register each document, but there are fee reductions if your assets are limited or if you are in receipt of certain benefits. Once registered, your lasting power of attorney is rather like an insurance policy. You would rather it is not needed, but you, and especially those you appoint, will be glad that you did take the time to put it in place. If the power of attorney does need to be used, you or your attorneys will need to provide a certified copy to each bank and other financial organisation where you hold funds. A copy is not sufficient. There are strict requirements on making copies, and many financial organisations have their own requirements as well. Once in place, your attorneys, and you, if you still have capacity, will be able to operate your funds. A little word on health and welfare lasting powers of attorney. These have become more important as important as the financial documents. This is particularly so if decisions need to be made about where you live. In the absence of a health and welfare lasting power of attorney, no one has the right to decide where you live. In many cases, because the local authority has certain legal obligations, they will make decisions. The Mental Capacity Act lays down the process for best interest decisions, which should involve all the people relevant to a particular decision, but this does not always work in practice. If you have appointed health and welfare attorneys, they must be involved. So what happens if you lack capacity, but you have not put a lasting power of attorney in place? Well, this will probably mean that someone will need to apply to the Court of Protection to appoint a deputy. This is a longer and more expensive process than putting a lasting power of attorney in place. A deputy, once appointed, will be able to act in a similar way to an attorney, but they will be accountable much more to the Office of the Public Guardian, and each year they will usually have to complete an annual report setting out in detail how they have used your money and the decisions that they have made on your behalf. There is an annual fee payable to the Office of the Public Guardian, and the deputy will have to put insurance in place. For some, there is no alternative to this. Some people never have capacity. Others choose not to put a lasting power of attorney in place or feel that it is a decision that they can leave until later. A deputy might also be appointed even when a lasting power of attorney has been put in place, but perhaps because the attorneys are unable to work together or there has been a financial abuse. In that case, the Court of Protection will have revoked the lasting power of attorney and directed that a deputy is appointed. My advice is that we should all consider putting lasting powers of attorney in place, whatever our age. Arguably, they are more important than your will, although I would not wish to discourage you from doing that as well, but they enable the person or the people that you choose to be able to make decisions for you whilst you are alive, but because you are unable to do so. If you have any questions, please do feel free to call us or visit our website at ibblaw.co.uk. Thank you.